Good morning, Liberty. It is Monday morning, February 25th, 2019. My name is Michael Boldin, broadcasting to you live. It is 9:30 a.m. Pacific time here on the West Coast in my home office and studio in downtown Los Angeles. So good morning to you if you're watching us live on the live stream here through our YouTube channel, or good afternoon, good evening, whenever you happen to be tuning in, wherever you're watching or listening to the show. I'm very grateful for you spending part of your Monday with me today. I hope you had a wonderful weekend. I totally checked out and I've missed basically all kinds of things that happened over the weekend, but I see that a number of people sent in emails and we got a bunch of new members that signed up. So I'm thankful to everybody who has been reaching out and supporting us as well. Now, today I want to talk about, not really in detail about asset forfeiture, because I did a full show on asset forfeiture. It's two forms, state and federal, back in early January of this year. And I'll have a link to that in the show notes, plus all the other things that I plan on talking about. They're all in the show notes here on YouTube. And then, of course, if you're watching or listening in the archives, we have those all over at 10thamendmentcenter.com/goodmorningliberty. Again, 10thamendmentcenter.com/goodmorningliberty. It's all spelled out. That'll take you to our podcast page where you can get all the archives, the links, and all the places that you can subscribe to the show. So asset forfeiture, specifically about this case in Indiana. This case, I think it's Timms versus Indiana. The opinion was put down unanimously by the Supreme Court recently. And I've been hearing, even before the case, anytime we report on efforts to stop state-level asset forfeiture or opt out and nullify federal asset forfeiture, we always have a few people telling us that the Supreme Court is about to strike down asset forfeiture. This was beforehand. So we should just put our efforts behind that. And the state actions are pointless. What's the point? It's already gone. The Supreme Court is taking care of it. And then afterwards, now we're hearing two stories. One, now, there are some people that are telling, I think, the real story here, but I think a lot of people are living on hopium. They're really just excited that potentially something has happened, or they're desperate for something good to happen. And almost never do you find that actually happening in Washington, D.C. So they're really excited about this Supreme Court, and they really want to believe that the Supreme Court is going to stop something bad. Asset forfeiture being a total ripoff, a robbery, a theft, whatever you want to call it, but government sanctioned. And so we're hearing from people that, oh, well, the Supreme Court either struck it down, stopped it, it did not, or it struck a blow against civil asset forfeiture. And that really implies that something significant happened in regards to the practice in effect. And I don't think that's the case either. So I want to get into that. I don't think it's going to be a really long show today, but we'll see. I often ramble and get into kind of side topics. So those of you who enjoy that, I'm grateful. But I'll just keep doing what I do. But before doing that, of course, I want to say hi to all my great friends out in the live chat, everyone who joins me here on YouTube Live, Scouse Jack, Joseph Standrich, Justin Bayola, Existence, Ward Lawrence, Bob Brewer, Denver Libertarian, Jazz Creed, EHP Training. You guys all rule. And as EHP points out, if you like the show, make sure to smash that like button. Wherever you are, whether it's YouTube or elsewhere, just smash the like button. It tells whatever platform you're on that they should show it to more people. So I really appreciate that. So let's get into it here today. And I'm going to just do a quick overview of the Timms case. And this was an article in The Federalist. I think it actually was just this morning. I don't often read The Federalist, but this one came across, just happened to see it, and I thought, wow, this is a good addition. So here's a basic rundown of the Timms case. The crime in Timms involved drugs, as forfeiture cases almost always do. Another reason the war on drugs should end. It is unconstitutional, at least, especially on the federal level, and probably violates most state constitutions as well. The drug trade produces a lot of money, and the drug war goes on seemingly without end. And of course, the amount of money it produces is because it's a black market, and then only criminals want to get into it, and only people who are willing to spend exorbitant prices, of course. But this is a discussion for other people, probably. The result is a constant stream of illegal cash and goods that governments have been all too happy to confiscate. Oh, and before getting to that, I do want to mention again that episode here. This is, if you're watching, the episode was on January 9th of this year. If you're looking for an overview of what asset forfeiture is, that's the episode to listen to. I did talk about bills to stop them in 5 different states at that point. I'm going to cover a couple of states that are taking action now as well. But this explains the two asset forfeiture programs. One, the state level one, civil asset forfeiture, where they're just stealing stuff. They basically charge property with a crime, and then you have to prove that it wasn't involved in a crime to get it back, and that almost never happens. And the billions of dollars that they're taking to fund their activities doing this. And then, of course, the federal equitable sharing program, the short version, is when states actually restrict asset forfeiture on the state level. The feds come in and offer it on the federal level. So what happens is the state police will then say, well, we can't seize this property, this car or this house or this cash under state law because it's illegal. So we'll call our federal partners, and they always call them federal partners in the Department of Justice, FBI, DHS, whatever, and they say, oh, okay, we think this is a federal case. Is there a federal law that this works under? And through a process known as adoption, it becomes a federal case that the state and local people still end up handling. They do most of the work under the direction of one or two federal agents that are assigned to the case, and then under the forfeiture, the feds take 100% of the proceeds and then divvy out about 80%, sometimes it's less, back to the local people. So it's an end run around that. So it's essential for states to stop that. So some people have been telling us, oh, this Supreme Court case ended this, and this is totally incorrect. And I don't think it even is going to do, personally, I don't think, and here's a jump ahead, personally, I think it has the potential to do more harm than good, but we'll see in the long run. So back to the case, Timms versus Indiana. So Timms pled guilty in Indiana state court. This was a state criminal activity to dealing heroin and was sentenced to a year of house arrest and 5 years of probation. I believe that the amount of heroin he was dealing was small. I don't think he was a large producer. Someone can correct me if I'm wrong on this. But from my very cursory understanding was that he was a small-time kind of local dealer. I don't know, maybe he was a user and had extra and shared it with his friends or sold it to people he knew. I'm not sure. But if you just look at the sentence, the fact that it was house arrest and not prison, that tells you he probably wasn't a massive distributor. Because Indiana is no joke on this, I think, on the law on this. So he was sentenced to a year of house arrest and 5 years of probation. The state also decided to seize Tim's Land Rover. So under civil asset forfeiture or criminal asset forfeiture, civil asset forfeiture, they say if they believe that your property was used to help effectuate a crime or carry out a criminal activity, they will take your property. There's a case of a man whose son was dealing drugs, very small amount, that they seized the dad's house from his 19-year-old, where his 19-year-old kid was living. I'm not sure how that played out. But in this case, they took his Land Rover, which he had recently purchased for $42,000. And now this article goes on to say the state, that's pretty typical in civil forfeiture. It is common for them to take cars. But Timms' lawyers raised an objection. The maximum fine for violating the law in question is $10,000. So Indiana state law is very specific on this. They say for the level of the dealing of heroin that he did, the maximum fine is 10 grand. And they took $42,000 worth of property. So the question, how can the state relieve the defendant of a car more than 4 times that amount? Just because the proceeding was in civil court, why should the state be allowed to go beyond the limits set by the legislature? And that was the question before the Supreme Court in Timms versus Indiana. Now, the whole process is something known as the incorporation doctrine. And I'm not going to get into any detail on this in this episode. It is worth its probably multiple episodes. This is the idea that the Bill of Rights applies to state governments and that the central government, the federal government, probably through the courts, is the enforcement mechanism to force the states to comply or participate with the Bill of Rights. Now, no one who has studied this in any way ever makes the case that the founders originally drafted the Bill of Rights to apply to the states. No one thinks that. The founders all said that it was meant to apply to the federal government. So many people are on the side of that just in theory. Well, of course you want the states to do this, but there's reasoning behind why the founders didn't want that to happen. They didn't trust a centralized government to actually enforce things against states. They were concerned about the central government encroaching on the states. Now, of course, states and all levels of government do bad things, but the idea of a one-size-fits-all solution to supposedly protect us can be as bad as something that is dangerous to us, because when they do things wrong, then it affects everybody. And one state does it wrong, it only affects that state. Unless, of course, it's California and everybody wants to follow California, but that's another story. So that's the general rundown of what incorporation is all about. It really didn't start until about the 1920s. And that's decades after the 14th Amendment, which is what they use as justification for the incorporation doctrine, was passed and supposedly ratified. And the 8th Amendment, the excessive fines clause, amendment, has never been incorporated against the states by the Supreme Court. Now, just to be totally clear, I'm not on the side of incorporation. I think it's wrong. I think it's done by judicial fiat, and I don't think it should have happened. And I think it actually has created many bad outcomes. And I think that would be the other show that So first, at some point, and I've been talking with Mike Meharry, Dave Benner's done a lot of great research on this. He's got a book on this called The 14th Amendment and the Incorporation Doctrine. I actually think it has provided us bad results, and I think that's where it's going on this as well. But rather than getting into my opinion, let's talk about this case again. So the Supreme Court was really answering the question, does this situation look like an excessive fine under the 8th Amendment, and therefore, and also, does the 8th Amendment apply to actions of the state government? And certainly, looking at this, I can see that if the legislature, I don't know how else to say it, but man, they always tell you, like, ignorance of the law is no excuse. But when you actually know the law and you make your decision on how much risk you want to take for violating that law, because that's basically what this guy Tibbs is doing. And I'm not sure if he knew what the potential fine was. Like, okay, can I lose up to $10,000 if I do this? Well, okay, maybe that's enough risk for me. And then all of a sudden they take 4 times that much. And it's a total ripoff. I don't know how else to put it. But just like any business decision, even if the business decision is considered illegal by the government, if you can't make a decision based on what your cost-benefit ratio is, you're being screwed royally. I mean, like, really, really bad. And the fact that the state government did this to him, I think, is very evil. Like, if I don't agree with the drug war. I don't think people should have their property taken or go to prison if they haven't done violence against other people. That's just my personal philosophical position. But I do acknowledge that this exists. So, like, okay, if you're going to fine him for what you said you're going to fine him. Don't quadruple it. I think that's really, really evil. So I can recognize how people are cheering the idea that, look, this was excessive and the state of Indiana should be stopped. So that's what the court addressed. And this other article here from Ilya Somin, who I think does a lot of really good research. He's a constitutional scholar. I don't always agree with him. He writes at Reason Magazine, which has never been friendly to us here at 10thamendmentcenter.com. He actually writes for the Volokh Conspiracy, which was its own independent law professor blog that's now being hosted by Reason, I think, to get more reach. They were at the Washington Post, and I'm not sure that went over too well. It's mostly conservatives and libertarians, so it's kind of this mix over there. So here's what Ilya had to say. He says, the key questions before the court are whether the excessive fines clause of the 8th Amendment is, quote, incorporated against state governments, and if so, whether at least some civil asset forfeitures violate the clause. The justices answered both questions with a unanimous and emphatic yes. Yes. As a result, the ruling could help curb abusive asset forfeitures. That's interesting. I didn't even actually realize the impact of what he's saying there until I was reading it out loud here. So there's a lot of caveats in his statement. The ruling, and I don't think the Supreme Court ever issues rulings. They issue their opinion, of course. And their opinions are not law. But the Supreme Court's opinion has the potential to help slow down some abusive asset forfeitures. Not all. It hasn't stopped them. It has the potential to maybe do something later on in the future. So going on, he actually cites quite a bit of the majority's opinion, and there were some other ones written by, for example, Clarence Thomas. But this is Ginsburg. He cites a lot of it. If you want to read through it, you can. It's basically talking about the history of the excessive fines clause, where it comes from Magna Carta, how they incorporated, etc. And then he talks about how Clarence Thomas actually looked at it from a different perspective, but still ended up with the same result. But he puts it this way. In sum, the court unanimously agrees that the excessive fines clause applies to state governments and that it covers civil asset forfeitures. That is a potentially significant victory for property rights and civil liberties because it could help curb widespread asset forfeiture abuse. While virtually all states have similar clauses in their state constitutions, many are not aggressively enforced by state courts in asset forfeiture cases. So the big question that was left open here, the court, and this is how Ilya puts it, the court did leave one crucial issue for future consideration by lower courts. And this is how it's like it has no impact right now, and it potentially has none in the long run. I look at the McDonald case regarding the right to keep, I'm jumping ahead. But the McDonald case, I think, is one that kind of informs my personal opinion on this. But let's look at what Ilya had to say. The court did leave one crucial issue for future consideration by lower courts. So he's expecting nothing to happen now and only for the Supreme Court's a current ruling or opinion to be held as a new standard in future cases on civil asset forfeiture in federal courts. That's it. That is all that's happening. But what is that standard? He says the question of what exactly counts as excessive in the civil forfeiture context. So in this case, they said 4 times the amount of state law was considered excessive. What if the legislature changed the law? What if the legislature then said, well, just to make sure that the Supreme Court doesn't stop us, we'll just change the law to, well, the maximum amount in this case is $100,000. Because what they're saying is that they didn't actually address the ability of the state government to actually use asset forfeiture at all. They didn't actually address the ability of the state government to use asset forfeiture without a criminal conviction. Mind you, he pled guilty. So I think a lot of people, myself included, really separate civil and criminal. The idea, I think, that we're moving towards, at least in our activism. Now, and I think there's a very good argument to be made that there shouldn't even be criminal asset forfeiture. But setting that aside, the notion that they can take your stuff on the mere suspicion that you may have used it in the course of criminal activity, or you may be benefiting from it in the course of the criminal activity, or in the case of the father whose kid, I don't think he knew the extent of the kid's drug dealing. Maybe he thought he had a drug problem. I don't know. It seemed like the father was kind of involved in understanding that his kid was going through some issues. But the fact that they took the parent's property because the kid was abusing it, because the parent didn't kick him out or something, I don't know. It seems pretty nuts to me. But they're not actually addressing that they can't do civil asset forfeiture or can't do criminal. They're just saying if it's too much, then they have to cut back. So then what would happen? I guess that's my question. What happens if they raise the rate, the level? Then does there have to be another case that goes to the Supreme Court and say, well, is $100,000 too much? I don't know. What does the court say in that opinion? Oh, the maximum should only be about $15,000. And then and this leads me to how it can become bad for everybody. Because then if the Supreme Court says excessive in this case is $15,000, that actually discourages another state from going down to $5,000 or $1,000 or $0 or keeping it at $10,000. It then becomes the new standard for the whole country, and it's this kind of squishy, really weak, bad opposition to asset forfeiture that really ends up, I think it perpetuates it potentially. So Soman, I apologize for that aside, but Soman says this is likely to be a hotly contested issue. So what counts as excessive? This is going to be a hotly contested issue in the lower federal courts over the next few years. The ultimate effect of today's decision or last week's decision depends in large part on how that question is resolved. If courts rule that only a few unusually extreme cases qualify as excessive, the impact of Timbs might be relatively marginal. But hopefully that will not prove to be the case. I think he's being very honest here. He's not, he doesn't sound as aggressively pissed off about it as I am, because I think it's a message that's getting out there that the Supreme Court is protecting us. And I think it's very clear that at best, the Supreme Court is just avoiding the question altogether. And maybe because, for example, I'm opposed to incorporation for many reasons. Maybe the Supreme Court shouldn't have touched it in the first place. But since they did, I think it's important for all of us to understand what they did and didn't do. They did not stop criminal asset forfeiture. They did not stop civil asset forfeiture. They created a scenario where future federal courts might call some asset forfeitures to be excessive. And then it is, I guess, up to the legislature to trust them to not raise it to make it worse. So Indiana, could they go in there and actually put this up to $42,000? I don't know. We'll actually see how that plays out. Gerard Perry. Oh, good to see you, man. Haven't seen you here for a while. Stephen Kinsella has a good summary of this decision on his Facebook. I like a lot of the work that Kinsella does. I did not know that he had posted something about this. I also want to say hi to Voodoo Doll and Gerard. I appreciate you joining. Bob Brewer, fee out of a judge that wasn't a judge. Hugo Black. Justin Bayola said, I thought they used a misinterpretation of the 14th Amendment as how they force compliance on the states with the Bill of Rights. And that's what I believe as well. And I would say most people in my realm disagree with me on that. That's fine. I'm gonna hold to what I believe is correct, whether there's one person with me or a zillion. So that's just how I'm going to do it. So I guess the short version of this shorter than usual episode is that the Supreme Court really didn't change anything other than the potential for some asset forfeiture cases to be seen as too much. So that means it is still incumbent upon the states or the activists who oppose this to actually work to end civil asset forfeiture and opt out of that federal equitable sharing program that I'm talking about. And I do want to mention, just as we get to the end of the show here, a couple of states, or looks like 4 pieces of legislation that we're tracking currently on this right now. So in Missouri last week, House Bill 444 from Representative Shamid Dogan addresses solely the federal equitable sharing program. The Missouri state law on the books currently is actually very good. Institute for Justice, who actually represented Mr. Timbs in that case in the Supreme Court, they're actually very good on asset forfeiture. This is like one of the best organizations to work with on that. But they rated Missouri state asset forfeiture program one of the best in the country as the least damaging. But like we had here in California for many years, you have really good restrictions on state asset forfeiture. They just start calling their federal partners and start looking at everything as a federal case. And we don't want to make a federal case out of everything. Anything, really. I mean, well, I'm speaking in absolutes. I shouldn't do that. So they had no restrictions on the federal equitable sharing program. So then what local law enforcement, state level law enforcement was doing, they were just passing everything off to the feds and raking in millions and millions of dollars and doing things that would have been illegal under state law. And that is just nasty. It's evil. It's wrong. So kudos to Shamid Dogan, who has introduced this bill for a few straight years. I think this is the 3rd straight year. It always gets ignored, and it looks like finally it's moving forward. And in fact, he actually set a bar that anything under $100,000 in value could not be transferred to the federal government. We know from research, at least from the Colorado, I think like League of Counties or something like that, that about 85%, at least in Colorado, and I think this is probably similar around the country, about 85% of all forfeiture cases are under $50,000. So a lot of people, when they file legislation, they're using this as a bar. They usually use $50,000, $100,000, whatever it may be. The idea is that law enforcement lobby groups are so aggressively against any restrictions on asset forfeiture, that they end up killing any bill that doesn't leave them any kind of loophole at all. So I think the argument that is made is, well, if we don't give the law enforcement at least some asset forfeiture and cut back on it, then we're not going to stop anything. So I'm actually in favor of the step-by-step strategy. You start with a $50,000, and let's say you stop 85% of the federal equitable sharing asset forfeiture situations in the state. That's very good. I want to see 100. So at $100,000, it's probably like 90, 95%. It's most. But surprisingly enough, and most times when a bill goes into a state legislature's committee, it gets watered down. This is a very rare situation where it went into the committee and they made it better. They actually removed that limit of $100,000 and they made it no limit. So the state is banned from transferring, using the adoption and equitable sharing program to do an end run around state law in every situation. And it passed unanimously. So at least out of committee. That was House Bill 444 in Missouri, and that is going to the state House floor in the near future. It has to get through kind of a technical committee, which I'm pretty sure it will. So if you live in Missouri, you definitely want to support that House Bill 444 and get it passed out of the state house. The other bill that I think is very interesting along these same lines is in Maryland, Senate Bill 764. It's the same type of process. They have pretty good asset forfeiture restrictions on the state level that were signed into law by, I think it was a former governor, Larry Hogan, in 2016. But they are fully participating in the federal equitable sharing program. So Senate Bill 764 from Senator William Smith, I think he's in Baltimore, would opt out the state completely from that program. Totally. It is up for a hearing and likely vote on March the 12th, so in just the next couple of weeks. So if you live in Maryland, you definitely want to get behind that bill as well. That would strengthen and take a follow-up step to what they already did a couple of years ago. Similar bill, not as good in Tennessee. Tennessee is very difficult to get anything good passed. The Republicans there are they're just bad. There are a handful of very good ones that keep pushing, though, on very specific issues. So one is good on one issue, another one is good on another issue, and they keep filing legislation. Most of the time they kill it. So the establishment people, it is good old boys network there to the max there, Mississippi, a number of other states, South Carolina usually. So last year, actually it might have been 2017, they signed some modest reforms on the state level program. And House Bill 340, which is up for consideration now, would opt out, I think, at the $50,000 level. So about 85% of the federal equitable sharing program. And here's what happened. It was actually going to be up for a vote on the 19th, so last week, Tuesday, February 19th. But there was such aggressive opposition to the bill from law enforcement lobby groups that the sponsor, Representative, I think it's Martin Daniel, Representative Daniel, and State Senator Nicely on the Senate side. So Representative Daniel actually pulled the bill from consideration because it is up to the sponsor of when they want to, they say, run the bill and get a vote, up or down vote in, this is in a subcommittee. So I think there's 5 or 7 members of this subcommittee. And the law enforcement lobby was so aggressively against this that he thought it was best to try to build more grassroots support. It's like give or take one vote whether or not this bill could pass out of the subcommittee, which means it goes to the main committee. And if it passes that committee, then it goes to the House floor. So it's got a ways to go. They have a 2-year session, but generally most things have to get through in the first year. So House Bill 340 is expected to be up for another chance for a vote probably next week, Tuesday, the first Tuesday in March, whatever the date that is. So again, if you live in Tennessee, we have a link to this in the show notes. And of course, again, over at 10thamendmentcenter.com/goodmorningliberty. And then the last bill I want to cover briefly here is in South Carolina, which I am blown away. Something must have happened. Anybody who lives in South Carolina can tell me. I don't know. Something must have happened because there have been a number of efforts to take action on this. People like Tom Davis, a state senator, Republican, kind of a Ron Paul guy on the state Senate side, and then Todd Rutherford, the House Minority Leader, Democrat, has always been pretty solid on this as well. But House Bill 3968, at the last check, when this report was filed by Mike Meharry on February 14th, already was up to 78 co-sponsors in the state house. Now, that is enough sponsors for it to pass the State House. So it is up to the House Judiciary Chairman to schedule a hearing on it, to schedule an executive session and a vote on it, and get it to the House floor. Then it is going to be up to whoever chooses, is the Speaker, whoever chooses, maybe it's the floor leader, whoever chooses what bills get voted on. So there are a couple of leadership positions, but the chairman of the Judiciary Committee is a co-sponsor of this bill. So House Bill 3968 would virtually end both state and federal. I think there are probably some minor loopholes, so I think we'd get to maybe, let's say, be conservative about 80 to 90% of all civil asset forfeiture would be ended in South Carolina should this pass House Bill 3968 in its form right now. Now, as we saw in Missouri, they actually made it stronger on the committee end, so who knows? There seems to be a lot of left-right coalition building on this. So it is bad when the establishment people on both sides don't want to support it. So in Tennessee, the chair of the committee, kind of an establishment Republican guy, he's big on supporting law enforcement. So he thinks law enforcement should be able to take... I mean, if you support law enforcement, don't you want to support the Constitution, your state and federal? Because that's what they take an oath to do. You don't want to encourage them to do stuff that is going to make the public and the people they're supposed to serve pissed off at them, angry at them, hateful of them, resentful. That creates a situation that's dangerous. The way to support law enforcement is to create boundaries where they don't do stuff that is outside their constitutional limits, because that creates a situation of trust with law enforcement. People understand the boundaries. For example, like Tim's, here's someone, and I think many grassroots activists now are disgusted with the people who wanted to take the $42,000 car in a situation where they were only supposed to be able to take $10,000. They look at these people as disgusting. I do. I hope you do. I'm assuming most of you watching or listening do. So I don't think you are pro-law enforcement just if you give them no limitations. I think you're anti-law enforcement. So that's just my opinion. So House Bill 3968 was just filed this last month. It's not necessarily a fast process in South Carolina. They also have a 2-year session. Most bills do need to get through in the first session. It's rare when something that doesn't pass in the first session goes into the second session of the, I don't know if that's the right term, session. But hopefully this has been really interesting for you guys. I hope it's been insightful. For those of you who live in the states that I mentioned, you definitely want to call your state representatives, state senators, get them to support these particular bills. If you're not in those states, you can use the links in the show notes or in the bill reports to the legislation and send it to your own state representative and say, this is something that I like. This is something that I want to see you do. It's very, very important to be active. I know a lot of people listen to podcasts or watch shows on YouTube to just kind of get ideas, or it's interesting. And I hope you find this interesting and even fun, entertaining, me blabbing. I hope you find it interesting and fun. But more importantly, I think this show, this channel is dedicated to doing real boots on the ground activism in the big picture to advance things that advance the Constitution and, more importantly, individual liberty. So again, I'm very grateful for you guys. If you support the show, make sure to hit that thumbs up. There's a lot of great people who are also members here, and I'm very grateful for everybody who's donated, become a member, etc. You can do that for as little as $2 a month. Do not feel under any obligation to do that. I'm going to continue doing this, whether you guys are donating or not. But if you want to support us, it's 10thamendmentcenter.com/members for as little as $2 a month. I'm very grateful for every action you take, whether it's listening or watching quietly, hitting that like button, leaving some comments, emailing me over at team@10thamendmentcenter.com. All that stuff. Thanks again for watching. I hope you guys have a great Monday. We'll be back, as we always are, every Monday, Wednesday, Friday, 9:30 a.m. Pacific time. And I hope you have a great day.